And I want to thank the Achieva family for having me speak today. It's an honor to add value and hopefully provide some education to the community and to the service providers on an important topic, which is sort of understanding guardianships and powers of attorney in Pennsylvania. So as Patty said, I am Nora. I am an estate and trust planning attorney. I do have a niche in special needs and long-term care planning. So when the past presenter was talking about the waivers and the look back, that's all stuff that I deal with on a regular basis. And it's been a pleasure to work with Achieva and its consumers over the last almost 20 years with special needs and related planning. So as I mentioned, we're going to talk about decision-making options today, which is very important, not only for people who are advocating or have special needs loved ones, but for all of us, because the longer we all live, statistically, we are likely to experience some incapacity. And if you look at the statistics, over age 80, the percentages, every 5 years or so of getting dementia and potentially having a cognitive impairment that way are really high. And of course, people have, medical issues, accidents, things that may happen unpredictably at any time in life that may affect capacity. So it's important not only for the special needs loved one or person for whom we're advocating to ensure that they have decision makers in place at the right time, but it's also important for us to think about individually. And one of the things that I do in my practice is I work a lot with families that are doing their estate planning for their special needs loved one. And of course, part of that is ensuring that the will is in place and the supplemental needs trust and how things are going to flow and making sure beneficiary designations are coordinated and we have the right trustees like Achieva to administer assets when the parents can't or the grandparents can't. But as part of that, sort of the value that I try to add is helping my clients understand and really come to terms with and not be in denial about the fact that at some point, they may not be able to be that advocate for their loved one. And that's a really hard thing for a lot of my clients to wrap their heads around. And it's really, really scary. I can't imagine how scary it is, but I see what my clients face. And so it's important for the parents or the grandparents or whoever the advocate is to not only say, hey, when little Johnny turns 18, what sort of decision-making paperwork do we need in place for him? But it's also important to think about, look, when I'm, have dementia or I have a stroke and I am all of a sudden in the hospital or in a rehab facility for a month, who is going to step in and care for little Johnny? Who's going to make decisions for me? But what is this going to look like? Not only from legally papering the decision-making, but also having a plan in place. And I think that's really sort of one of the goals of this conference is future planning. And I'm sure someone has talked about it or will talk about it, but Achieva does have a really great, very comprehensive future planning guide that it has put together, which is available on its website, which really helps families to think about all of the things that they need to consider, not only the legal aspects that I can help with, but okay, if all of a sudden we are in a car accident and my husband and I are in the hospital and little Johnny needs to go somewhere else, where is he going? And what sort of roadmap do we need to have for these other alternate caregivers to ensure that he is getting his services and that his routine is not impacted any more than it already has to be? So somewhat adjacent to the topic today, but I wanted to make sure that was underscored because it is a really, really important part, integral to the future planning. So we're going to talk about agents, guardianships, and statutory and supported decision-making in Pennsylvania today. A lot of these concepts apply in other states as well, but they may use different terminology and have slightly different laws. As you're going to see, my slides are really detailed. I have a lot of, actual statutory citations. Some of them are very voluminous. I'm going to sort of gloss over those and try to get to the meat of it. But these would be available as a reference for people to go back and look at. While we're having today's presentation, this is being live streamed, so we want to add value. So if someone does have a question, if something I have said doesn't make sense or you'd like me to elaborate it upon, please feel free to raise your hand. I will repeat the question and then answer that. Some of you may have really specific personalized questions. And if you think that those would add value to the group, we can talk about them, obviously on an anonymous basis, but those may be more appropriate to talk about after the fact or separately. And my contact information is available on the slides, and I believe the Achieva Family Trust website as well. So let's just talk a little bit about what we're doing. And we want to recognize the types of legal decision makers that are provided for under Pennsylvania law. And, we have a power of attorney instrument, and maybe telling you things that you already know, but just to make sure we're all on the same page. Power of attorney is a document that someone who is over 18 and has capacity signs, by which that person, and that person is referred to as the principal, that's our legal terminology, by which the principal designates an agent and maybe multiple agents and maybe successive or successor agents to act on his or her behalf with respect to whatever's covered in that power of attorney document. So it may be a financial power of attorney giving authority to the agent over legal matters, financial matters, banking, public benefits. It may also be a healthcare power of attorney, meaning that it gives the agent the ability to make healthcare decisions for that individual and to access health information. And sometimes these power of attorney documents are combined into one. Oftentimes they are separate, and there's a separate financial power of attorney and a separate healthcare power of attorney. They can be crafted different ways, but it is really important that when these are being put in place, they be carefully thought out, because under Pennsylvania law, as we'll see, if you just download a form from LegalZoom, number one, it may not comply with our Pennsylvania law execution requirements, so that when you go to present it to a bank or to the IRS or to the Department of Human Services, they can't honor it because it's deficient in some way. It's also possible that it doesn't contain broad enough powers. And a great example of that would be a financial power of attorney. Unless it specifically says that it allows for unlimited gifting or the ability to create trusts, the agent doesn't have that authority under Pennsylvania law. So I've had clients that have either worked with other attorneys or downloaded forms. It's great. It says it's a comprehensive, financial power of attorney. But when my principal is now incapacitated and can't sign a new power of attorney, and the agent needs to do some planning, maybe for waiver benefits or something else, needs to fund a supplemental needs trust or an ABLE account with my principal's money, if that power of attorney doesn't contain broad enough authority, it doesn't carry the day, meaning that we may need at that point to revert to a guardianship. A guardianship, and so the big premise is a power of attorney is for someone over 18 who has the capacity to give someone else authority to act on his or her behalf. And we're going to get into what is that standard. That is distinguished from a guardianship. And a guardianship is where the person in question lacks the cognitive capacity to sign that power of attorney document. Either they've had a traumatic brain injury or they've had something else, and they are really in a very poor cognitive state. There's no way they could understand even the high level of what that power of attorney says. There's no way they could give consent for the parent or the grandparent to act on their behalf. When that happens and someone is over 18, we need to go to court to get a guardianship. And that's where a petition is filed with the court. The petition essentially, there's a statutory framework, which we'll see, but it essentially says, look, Johnny, now 18, is believed to lack capacity for these reasons. This is his diagnosis. These are the doctors that have said that. These are the places that he's treating. We have to list next of kin. We have to list assets and income. And the court then takes that information, has a hearing, and decides whether or not, in fact, little Johnny, I'm going to call him Big Johnny now, is incapacitated and needs to have a court-appointed guardian. So the big distinction between a power of attorney and a guardianship, power of attorney, someone has the capacity to sign it. They are deciding who's going to be the agent, who's going to act on their behalf, and they are deciding the extent of that agent's authority. Whereas with a guardianship, the person lacks capacity. So the court determines they need a guardian. The court decides who that guardian is, and the court decides the extent of that guardian's authority. And with a guardianship, sometimes it's inevitable because our person in question lacks capacity. But when we do have to go that route, we are subject to the court's jurisdiction and oversight. And the statute very clearly delineates what that guardian can and can't do. And that filing takes longer, it's more costly. And that person who's then appointed as guardian has to file annual reports with the court and to do certain things like to fund a trust or to spend principal or maybe to ask for, ECT therapy. They have to go back to the court to ask for approval to do that, whereas that isn't the case under a power of attorney. So as you can imagine, a power of attorney is generally sort of the preferable path of least resistance when someone has capacity. Whereas a guardianship, and under Pennsylvania law, guardianship is supposed to be the step of last resort, meaning we want someone to sign a power of attorney. We want to use community supports or supported decision making. But if those things are failing, then we do need to go to court to get a guardian, and then we are subject to the court's purview. And in some cases, being under the jurisdiction of the court is really helpful for individuals because the court is sort of monitoring whether or not the guardian is doing what he or she needs to do. And if not, the court will take proactive measures, which can add as a safety net for that incapacitated person. There is also in Pennsylvania something called a statutory decision maker, which means if someone is in sort of an end of life decision, it's not anything. It's not general banking. It's not deciding we're going to see Dr. A or Dr. B, but rather they are in a hospital. They are in hospice. They are in a coma in the ICU. If they lack both a power of attorney and a guardianship, there's a limited, very narrow instance where someone by statute can step in and make decisions. But it's really limited to sort of those end of life decisions for someone who is in extreme medical condition. And the statute dictates who those decision makers would be, starting with, a spouse, then a parent, then children. But that's really not going to carry the day because it doesn't apply outside of that end of life context or to anything financial or legal. So that's the high level overview of what we're talking about today. And what have I just done? There we go. Okay, so again, why is this relevant? Well, everybody needs to consider this, not just us, worrying about our special needs loved one and the advocacy. We need to think about this for ourselves because at some point, as I mentioned, the longer we live, we are more likely subject to dementia and to need decision makers. So this is relevant for everyone. And you want to do this planning while, if you're talking about yourself for a minute, while you have capacity. If you don't have a power of attorney in place and you have an accident or you have a stroke, your loved ones are then going to be scrambling to potentially go to court to get a guardianship. So everyone needs to consider it. Now, one of the questions comes up, well, what if the person in question, little Johnny, is in fact still little Johnny? He's not over 18, he's 16. Well, what happens then? And under Pennsylvania law, generally speaking, and there are some exceptions when we get to certain psychiatric care and records and certain other things, but generally speaking, for someone who's under 18, their parent and natural guardian sort of stands in their shoes and is able to make decisions, to communicate with doctors, to do these sorts of things. Again, certain exceptions, which we're not going to cover for purposes of today. And obviously, if someone's parents' rights have been terminated or there is a custody order, in that situation, the court order is going to determine who is advocating for that person. Now, when little Johnny turns 18, under Pennsylvania law, he is presumed to have capacity. Even if we know he was born with a traumatic birth injury, he is unable to read, to write, to communicate. We know he doesn't have capacity to do anything that's sophisticated, maybe even to provide for his basic care. That doesn't matter. Under Pennsylvania law, he hits 18, he is presumed to have capacity, which in theory means that his providers and other, entities, third-party entities involved in his life, at that point should stop taking the direction or sharing information with who was ever previously the custodian or the parent and natural guardian. Because under the law, little Johnny is now standing in his own shoes, he's able to make his own decisions, and he needs to authorize someone to act on his behalf, or a court needs to say he can't, and a court needs to appoint a guardian. That's what the law says. Now, in practice, does that happen? No, my kids aren't 18 yet, but I see it all the time with my clients. They have been the person taking the child to the pediatrician or whatever specialist that office, that doctor office, probably in a lot of instances is going to continue to work with the parent to share information. But in theory, they shouldn't. And at some point, there may be a change. Maybe that provider is acquired by a new health system or they merge. And all of a sudden now this new health system has really black and white policies and procedures. The parent who was previously the natural guardian that had authority, now with an 18-year-old child doesn't have authority. A wall might be put up, which I've seen this firsthand from my clients, that is incredibly frustrating. It's obvious little Johnny can't make decisions. You're in the best position to do that. You've been doing it. No one else is going to do it better. But now all of a sudden you are prohibited access or certain information. And so that's a question. Oftentimes clients ask, well, my son is 17. He's going to be 18 in December. What do we need to do? Do we want to make sure that we don't run into this obstacle? Some clients take a wait and see approach, and they don't proactively plan to have a decision maker put in place when their loved one turns 18. Instead, they wait until there is an obstacle, until they're denied access or something comes up. But more and more, I think that clients, and it's probably good, are being more proactive and coming to me or to Achieva or other advocates and saying, okay, my son or daughter is going to turn 18. What do we need to do? And that's when we have this discussion, do we need to have a guardian or a power of attorney? Now, the slides you're going to see talk about certain rules for people under 18. Sometimes if someone under 18 inherits money or is named as a beneficiary of life insurance policy, or is the plaintiff in a personal injury or medical malpractice action, we have all these rules as to what can happen when someone's under 18. Those are detailed on the slides, but I'm not going to get into those in a lot of detail today, but obviously happy to talk about it separately. So again, little Johnny is going to turn 18. He's presumed to have capacity. Our lovely Latin legal term is sui juris. And so what that means is the law presumes that when Johnny turns 18, he is able to sign a power of attorney instrument. I've had a situation where we were proactively planning and, clients, Johnny was going to turn 18. Clients made an appointment on May 10th to come in and have him sign documents. And those documents, as we'll talk about, have to be notarized. When we got down to sign, they said, oh, tomorrow's his birthday. He's going to be 18 on May 11th. Well, no, he can't sign until he's 18. So we have to wait till he's 18 years of age. And that notary is going to confirm his date of birth and check that information. Once he turns 18, he's presumed to have capacity. So at that point, unless whoever is involved really says he can't, we know he can't, or a provider is saying there's no way we would accept power of attorney instrument signed by him, even if it's signed by Mark, he just slashes the piece of paper with a pen. If they say we wouldn't accept that, then we know that we're going to have to go the guardianship route. So we've talked about the different types of legal representatives for someone over 18. Again, a power of attorney, financial health care. There's also something called a mental health care power of attorney. It's a separate statutory section. These can all be wrapped into one document that just details what specific authority needs to be in a power of attorney to ensure that the agent can take certain and make certain decisions that are deemed to be more important and maybe more invasive, like admitting someone into a residential treatment facility or inpatient psychiatric care, or authorizing ECT. And that has to be expressly spelled out in a healthcare power of attorney, sort of following what that mental health care statute says. And that's why just downloading something from the internet, ultimately may not carry the day, depending on the situation. So if we have someone who's over 18, they've signed a power of attorney, the law presumes they have capacity, and then that person becomes incapacitated, right? Let's say we have a loved one who has, a mental health issue, and they let's say they are bipolar, or they have schizophrenia, and they sign a power of attorney at 18, appointing parents as their agents. And then that person has a period where they are decompensated. They are now in treatment. They are heavily medicated. That power of attorney under Pennsylvania law remains valid because they signed it when they had the capacity. It is still valid when they lack capacity. And that's the exact reason we have these powers of attorney, right? I have one in place that says, if I become incapacitated, my husband is making my decisions. I want to have that legal decision maker teed up if I can't make them. So it is presumed to be valid and to sort of survive the incapacity. Now, if we have someone who can't sign a power of attorney, obviously we're going to go the guardianship route. And we do have a slide that sort of dictates the general comparisons between guardianship and powers of attorney. And a lot of this I've covered as well. But again, the gist of it is power of attorney, capacity, the principal decides who the agents are, what their authority is. Whereas with a guardianship, the court decides those things. One of the things that's really important to remember, and I see this in all walks of estate planning, whether it's tax planning, long-term care planning, people seem to think that if they have guardianship or they have, a power of attorney for someone, that survives that person's death. And it does not. The authority of a court-appointed guardian or the authority of an agent under a power of attorney instrument dies or terminates when that principal or that incapacitated person dies. And that becomes really important because we see this when we get post-death into sort of an estate administration standpoint where, parents may say, well, I was the rep payee, or I was the agent or the guardian for my son, and I have a fiduciary account, a rep payee account, an agency account, a guardianship account. It's me as a fiduciary, rep payee, guardian, agent for that person. They now die. Well, I can dispose of that money. I can use it for the siblings, or I can give it to their children, whatever the case is. And the answer is no. Technically, that authority ends, and then we go into an estate or trust administration, as the case may be. So you're probably saying, okay, well, you've said someone's presumed to have capacity at age 18. If they have capacity, they can sign the power of attorney. The big question clients ask is, well, how do I know if my loved one has the capacity to sign a power of attorney? And unfortunately, and maybe fortunately, there is no black or white test. It is a very, very sort of gray area. And again, the law presumes that someone has capacity, and in order for someone to say no, they didn't have the ability to sign that power of attorney, or they need a guardian, you have to rebut that presumption or overcome it and say, no, that person lacks capacity. And there are a number of court decisions where there have been disputes about whether or not a power of attorney was valid or a person needs guardian that talk about what is the standard for incapacity. And a lot of these decisions are sort of at the lower court level, which means they're not binding. We can look to them as sort of persuasive, but they're not precedential. And some of those have said that the capacity is the individual's ability to give consent and understand the power that he or she is giving to the agent. Another court, another judge, Judge Ott, out of the eastern part of the state, who's very well respected, has said it's the ability to understand the nature of the authority being granted, the nature of the assets, if it's a financial power of attorney, and the statutory notice. Now, you take all this, you say, well, what in the world, how do we decipher that? And so I'll tell you from a practical standpoint how I approach this with my clients. I will have someone coming in, Johnny is 17, he's going to be 18 in December, what do we do? And I'm not the decider of whether that person has capacity, right? Ultimately, the court is the arbiter or the person that determines, a judge is going to determine whether or not little Johnny had capacity. The law presumes that they do. My role as an attorney, my ethical rules basically say, look, I need to treat little Johnny as though he has capacity. And I sort of need to look for red flags. And if I truly think he doesn't understand, or if I think that no, the person who's bringing him in, asking him to sign the power of attorney is doing this for designing reasons, right? They have some motive. He has money in the bank, or he's going to inherit money and they want to be able to control it. I need to use those red flags to operate and handle that engagement in a way that sort of protects him. So I may decide, no, I'm not comfortable having him sign a power of attorney. I think he needs a guardianship. That doesn't mean that client couldn't go to another attorney down the street and they'd have him sign a power of attorney. Again, I don't decide if he has capacity or not. I just decide under my ethics rules, do I think this is appropriate? And if, that other attorney down the street has him sign the power of attorney, and we see this sometimes in two contexts. In this context, for today's purposes, maybe it's when parents are separated, right? And so, they really both love little Johnny and they have his best interest at hand, but one says up, the other says down. Sometimes they will use these powers of attorney to sort of play games with one another. So one parent has him sign it. The other parent says there's no way he could do that. Ultimately, they end up in court, and the court decides, did he have the capacity? More often than not, though, in this context, where I have clients coming in saying little Johnny's going to turn 18, the people that are bringing him in or making that question are the parents or the grandparents or the adoptive parents. They are people that have given their lives and will give their lives for little Johnny. And oftentimes there isn't money involved. It's more, we want to make sure we are not denied access. He has the best health care. We can be his advocates. So oftentimes in that situation, those red flags are not present. And I have that sort of ethical knowledge that they're going to do right by him. And if I have a gut that they're not, then I may decline that case or say guardianship. But how I start that conversation with clients, they say, well, what do you think? Even if little Johnny is nonverbal and only communicates with signs or signals or using an electronic device, I say, do you think he could really understand that he's giving you some authority? That doesn't mean he can read the document. Maybe he can't really read it and understand word for word. A lot of my clients who are very sophisticated or very wealthy, the powers of attorney contain a lot of legalese. They might not understand it. I have to explain it to them. But the question is, does little Johnny, in your perspective, would he have the ability to say, yes, I want mom or dad or grandma to help me, And sometimes I use the concept of trust. Sometimes trust isn't something that person can wrap their head around, but look, are you okay with mom and dad talking to doctors? Can they help you? And if the answer is yes, and the parents say to me, yeah, I think he can do that, and I feel comfortable, then I am generally going to have that person, I'm going to prefer the power of attorney route as opposed to guardianship. Now, that doesn't mean that we don't put that power of attorney in place and someone rejects it. That we could have little Johnny sign it. Maybe he can't even sign his name. He just literally signs by mark. I had an 18-year-old in my office yesterday who signed a power of attorney. She is not verbal. She communicates with a device. She signed, it's a bunch of loops, and that's valid. I was there, I witnessed it. Another witness did. We had a notary. But what I will ask the parents or the loved ones that are coming in is, number one, do you think this person has capacity? Sometimes they don't know. And then I say, well, you know what? You should ask some of their providers. And the question, and the providers may not give you a clear-cut answer. But the question is, if you ask the pediatrician or the PCP or the psychiatrist or whomever is the main medical network, hey, if we presented a power of attorney, would you accept that signed by Johnny? Sometimes they'll say, look, we can't determine if he has capacity, but if we are presented with the power of attorney, we will abide by it. Other times they will come back and say, no, there's no way he could have signed that. We think he absolutely could never formulate that capacity. We wouldn't honor it. And if the physicians wouldn't honor it, then, sometimes it's better not to fight with them. We could get another doctor that says they would. But in that case, we might say, okay, this is clearly a guardianship route. Sometimes it's so apparent, for someone who's nonverbal and is not really meaningfully communicate, we know we have to go the guardianship route. And if we do have to go that route, then the question becomes, when do we do it? Do we do it as soon as that person turns 18? Do we wait until you're denied access? And we don't, for an adult, we can't file that petition until the person is over 18. And there are guardianships for minors, but we're not going to talk about that. And those minor guardianships end at age 18. At that point, that minor is presumed to have capacity. So if you did have a situation where you were a guardian for a minor, when that minor turns 18, almost like, if someone's on SSI, they switch from a child determination to an adult determination. When they turn 18, we got to go back to the court and say, okay, now little Johnny is 18. He needs a guardian as an adult because he lacks capacity. How the guardianship process works is, in our office, we use a questionnaire. There are a lot of guardians that will serve for people. Jewish Family and Service comes to mind, Ursuline. They have sort of a questionnaire that asks a lot of pertinent information. We get that information, we put it into a petition, and we talk about what type of guardianship do we need. So just like with a power of attorney, how there's a financial power of attorney for legal and financial matters, and then there's a healthcare power of attorney for medical decisions, etc. Those same concepts, they pair over to the guardianship. And for guardianships in Pennsylvania, we have a guardian of the person, which means that if someone is appointed as guardian of the person, they are making the medical decisions. They are deciding where that person will live. They are deciding who their caretakers will be. There's also a guardian of the estate, or sort of a financial guardian. That guardian is overseeing, the bank accounts. They're overseeing, the tax filings, whatever other legal matters are happening. So when we go to court, we need to decide what sort of guardian do we need for little Johnny. And oftentimes I would say for 80% of my clients, little Johnny has never worked. He's not going to be able to work. We know he's going to have SSI at some point, but that's all he's going to have unless he gets an inheritance. But hopefully that inheritance is in trust, so it's not going to him directly. So in those situations, when I talk to the family, we normally decide that he only needs a guardian of the person. We only need to have the loved ones installed so that they can make those medical and those more personal decisions. We don't need them to be able to make financial decisions. Now, there's no harm in having both a guardian of the person and an estate installed, and they are oftentimes the same person, but they don't have to be. But the reason that we don't necessarily include that just for the heck of it is because, as I mentioned before, once a guardian is appointed under Pennsylvania law, they have to file reports with the court every year. And there's a separate report for guardian of the person, a separate report for guardian of the estate. The purpose of those reports is so that the court can monitor what's happening, ensure that the guardian is doing his or her duties. So in a way, that's a very nice sort of added value, right? There's some security that if we know that the uncle is appointed as guardian and he fails to do his job, the court's there as a check and balance and will, ask him to account or to explain himself, or they'll remove him and appoint somebody else. But from a practical standpoint, that can be really frustrating because these guardian reports, in the last few years, they have automated the report system. So in theory, it's making it easier. There's now a formal GTS or guardianship tracking system. There is a center in Harrisburg that gets these reports and it flags if there's an inconsistency. And if there is, it then tells the county where that person was adjudicated to be incapacitated. And the county is supposed to take measures. So the filing of these reports, even though it's really intended to serve a good purpose, it can be complicated. And I was just in Mercer County for a hearing this week where a mother was actually removed as guardian for her son. The dad is out of the picture. He actually gave up his parental rights. Mother is the sole caregiver 24/7 for her extremely disabled adult son. She was appointed as guardian in 2020, and we had her installed in Mercer County during COVID. And she's not a sophisticated internet person, but I can tell you, even if you are, these reports are difficult to complete. And so she actually had failed to file her reports. The GTS system flagged Mercer County. The judge set a hearing as to why they weren't filed. So he could say, should you be removed? Do we need another guardian? Or are you doing your job? Well, the problem is she tried to file the reports. She wasn't able to get them filed electronically appropriately. There was a disconnect with the judge's chamber. So he actually entered an order removing her. And we then had to file for reconsideration and have a hearing. And when she came, the judge clearly saw she is the best person. She was just not tech savvy. She didn't understand. She's going to rectify this. And if she needs assistance with those reports moving forward, she's going to get that either from me or from some advocacy group. But what the judge had told us is that this is a really common occurrence where a guardian of the estate, for instance, will file the report and they track how much because the guardian of the estate has to list how much income, how many assets, what they've spent it on. And literally the judge was telling me that there was like a $10 difference in what the previous year's report filed and what this year's report filed. And it was very easily explained. Anyone with a brain would look at it and say, hey, this is a non-issue. Let's move on to the next thing. But this tracking system didn't. And it created, more work for the court because the clerk then has to schedule these hearings. The judge has to investigate. So in a way, you can see it's good because people are monitoring what's happening, but it can also be somewhat burdensome. So for that reason, we oftentimes prefer to have, the power of attorney put in place where we can. So, we see these standards and oftentimes it is a gray area, whether or not that person has capacity. And as you can imagine, the capacity to sign something or really do anything, it may be very temporal, right? And we see this more in elderly persons, but it applies just as much to someone who's young, where, they may understand better if they have just taken their medicine, or, within the 3 hours after the medicine. They may understand better when they are in a comfortable environment. And I see this with my, clients with dementia. There could be a time of day where they can tell you everything. Another time of day, they don't know where they are. And so when we're having them sign the power of attorney, we want to make sure we feel that they understand at that moment we're signing. When we're dealing with, sort of this context, maybe younger persons whose parents or grandparents or caregivers are bringing them in, we have to think about what their condition is. So for instance, if I have, someone who we're considering having sign a power of attorney, and maybe they have autism, they may be really overstimulated coming into my office and a big building with glass windows and, it's real formal. They might be better off and feel more comfortable, and we feel that they understand better if this is done in a familiar setting with people that they know, or, with whatever supports they have, whatever comfort tools they have. So we need to think about that when we're deciding, can this person sign? What is the best way to do it? But there is this gray area where, and this is where this concept of supported decision making comes into play. And the gray area is, look, someone can understand, yeah, I trust my mom, or I want my mom to help me, but they can't understand that mom is making sophisticated investments or which tax decisions mom should make. Or they can say, yeah, I want to live in Homestead as opposed to Squirrel Hill, but they can't say which provider is the best provider or which one is going to give them the most services. They can understand sort of a certain level, but not high level. And when we get into the guardianship context, there are layers or sort of a spectrum of guardianships. You can have someone who's totally incapacitated, right? Someone who's in a vegetative state, totally incapacitated. They cannot make any decisions. So they are going to have a permanent plenary guardian of their person and estate who's making all decisions. There is something, and for whatever reason, lately the courts have been hesitant to go this route, even though it's statutorily required. But there is a concept of a limited guardianship, meaning little Johnny can say where he wants to live and who he wants to live with, but he can't make complex treatment decisions, or he cannot handle his finances. In that instance, we would go to court and say, this is what little Johnny can do. This is what he can't do. We want a guardian to be installed for these purposes. And again, a guardianship statutorily is supposed to be the last resort. We want to try to support little Johnny and give him the means to make decisions for himself to the fullest extent we can. And we should only go for a guardianship if we have no other way to get him what he needs. And so that's where this concept of supported decision making comes in, which is someone who can make some decisions. They have capacity to a certain extent, but they need guidance. They need support, right? And we don't have one in Pennsylvania yet, but Texas was sort of the prototype. They have a supported decision-making statute, and what this contemplates is, look, someone who can participate, who we want to respect their autonomy and their wishes, but we know that without the guidance, they cannot make decisions, or they cannot make decisions that are good for them. So this concept of supported decision-making essentially says, look, someone that has a good team, whether it's the family, the caseworker, the physicians, that team rallies behind that person and helps them to make the right decisions. And if they can do that with guidance, we want to avoid a guardianship. We don't want to take away their rights, because what a guardianship does do is it finds that person to lack capacity, and it takes away their rights to act on their behalf. So if you have someone who's been adjudicated to be totally incapacitated, they can't enter into contracts. They can't go get a credit card. If they sign a piece of paper, it's not valid. It was void when they signed it, because they have lost those rights. And we don't want to take away people's rights unnecessarily. And so that's what supported decision making is designed to do. And if that person has a good support team who's working together, they may never need a guardianship. But in the instance I gave you, where you have two parents who both want the best for little Johnny, but one says up, the other says down, that support team may not work. And so maybe we do need to go to get a guardian, and maybe even someone who's independent from the parents. And sadly, we see this quite often in some of these situations. And the supported decision-making statute in Texas contemplates a contract being signed, right? Sort of like a power of attorney, but different. It's almost like a document that says, little Johnny wants to live in this area. This is his best housing. He's going to rely upon X, Y, Z, and these people are going to be involved. And as part of that, he's probably going to sign a power of attorney as well. But it's sort of a roadmap to help him make decisions. And that contract or roadmap could be updated. But if it fails, that's when we then may need to go to get a guardianship. So that is what supported decision making is. And one of the things that I also see is that, again, the courts should not be adjudicating someone to be permanently and totally incapacitated if they have the ability to make certain decisions themselves. that guardianship should be limited. But for whatever reason, a lot of courts, and maybe it's because they think that gray area creates too much risk, but they really prefer incapacitated or not incapacitated. They don't oftentimes go that limited route. But one of the things that we see is when the guardian is appointed, the guardian, that person, little Johnny's incapacitated, he may have lost his rights. Guardian's now standing in his shoes, but his decisions and his preferences are supposed to be respected. The guardian is not now in little Johnny's shoes making the decisions that the guardian would make or based on the guardian's beliefs. The guardian is supposed to base them based on little Johnny's preferences and what's in his best interest. So, for instance, if little Johnny, was, a certain religion or had a certain sexual orientation, the guardian can't come in and say, no, I'm very Christian, or I don't believe in this, and we're not going to put him in this housing unit because it's not consistent with my beliefs. No, it's supposed to be, what would little Johnny want if he could do that? And sometimes we do see, some tension there. And particularly, candidly, oftentimes it is when we have, parents or grandparents who, they know what they want for their child, but any child, incapacitated or not, is going to want different things than their parents. And so sometimes that can create issues, but it's important to remember that that incapacitated person, what he or she would want, to the extent it's not harming himself or herself, really does need to be supported. So when we have, either the person signing a power of attorney, appointing an agent, or the court adjudicating incapacitated and appointing a guardian, oftentimes we ask, and both of those rules are fiduciaries, meaning they have a heightened ethical duty to the person's interests that they are serving. Who should be those fiduciaries, that agent, that guardian? Oftentimes the preference is for it to be the family member. But in some cases, that doesn't work, right? And a prime example would be, parents who are separated that can't get along even though they both want the best for little Johnny. Or we see this with, some of my elderly clients, the two children want vastly different things. And even though they both love mom, we got to have someone independent. And so sometimes we do need to have a corporate agent or a corporate guardian in there to make sure that there's not friction or fighting among family members or among other people who are within that person's sphere. One of the problems, as you can imagine, though, with an individual agent or an individual guardian, if we're talking about 18-year-old Johnny and we go in and we have the parents appointed as guardians or we have the parents as agents, unless little Johnny has a condition that's going to shorten his life expectancy, actuarially speaking, parents are going to predecease him. So there's going to be a vacancy there. So we need to think about what is the game plan. Even if parents aren't actuarially going to predecease him, they may want to go on an international trip for a month. They may go out of town. They may be in a car accident. Something could happen. So we need to think about, who's going to be the fiduciary now? Who's going to step in when the current fiduciaries can't, either because of age, because of death, something else. And so with the power of attorney instrument, we always want to have backup agents, right? So it may be we're naming parents. We may name them siblings or, an aunt or uncle. But then sometimes as a last default, we are naming a nonprofit, a corporate agent. So that way we never have a vacancy, because maybe little Johnny has the capacity to sign the power of attorney when he's 18, but something may happen with his mental condition and he can't then sign a power of attorney later. So if we don't have alternate agents, that power of attorney then becomes sort of a void document. Same thing with guardians, right? And again, the court appoints the guardians. So in most instances, a court isn't willing to say, I'm going to appoint mom and dad as guardians, and if they can't serve, I'm going to appoint sister. The reason is because mom and dad, when the court decides who the guardian is, they make that decision based on what it knows at that time. So yeah, in 2024, mom and dad and then sister make sense. But if it's not until 2034 that mom and dad can't serve, sister may be in jail, sister may be a drug addict, sister may be dead. So, the courts oftentimes say, look, we're going to view who should be guardian at the time we're making the request. So what I oftentimes do with clients, maybe mom and dad were the guardian, dad passes away, mom is now the sole guardian, she's 85, she's having health issues. Clients will come in and say, okay, what are we going to do? We need to worry about mom, but also, she's taking care of Johnny. She's his guardian. We may go in and have a sibling or somebody else appointed as a co-guardian. That way, if mother does pass or she's in the hospital, we don't have a vacancy in this authority. Someone is in charge and able to make those decisions. And sometimes we even do that for persons who are much younger, right? When we're going for the initial guardianship, if we have siblings who are over the age of 18, we may have them named as co-guardian with parents. Maybe the sibling is 21 and off at college. We kind of know that mom and dad are going to run the show. But if mom and dad decide they want to take that 2-week trip to Europe, they don't have to worry about who's going to step in because the sister is already co-guardian. She can make decisions while mom and dad aren't there. So those are the things that you have to think about in terms of who should be serving in these fiduciary capacities. And I want to talk just, a little bit about some of these execution requirements, because we do have very strict execution requirements for financial powers of attorney in Pennsylvania. And so for financial powers of attorney, there was a judge, Judge Lucchino, very well respected. He's now off the bench and I think retired in Florida, hopefully not in the hurricane. But he would say, a power of attorney is really a pretty powerful tool. And if Jesse James, the bank robber or the train robber, whatever he was back in the day, if he had powers of attorney, he wouldn't have needed a gun, because once he's that agent, you can go in and wipe out someone's finances, right? You're their agent. You can conduct banking, etc. So for that reason, we always want to make sure that whoever we're appointing is someone who is really trusted. And this concept, it becomes relevant in this power of attorney and guardianship space. But I also have this same concept when I'm discussing my clients' estate planning, right? Let's say they have 3 kids, 2 of whom are minors, 1 of whom has special needs. And we say, okay, when mom and dad pass, ultimately the assets are going to go a third, a third, a third. We're going to have, maybe trusts for the other kids if they're under 25. Little Johnny's money's going into a supplemental needs trust, so it never kicks him off benefits. And the parents will say, well, okay, who should be, the guardians if my kids are minors, or who should manage this money? And I always tell them, the responsibility, particularly to manage money or assets, is really, you got to put the right person in there. Even if the person has the biggest heart and they would want to do right by this person and use the money appropriately, if they don't have a good head on their shoulders, or they themselves aren't, financially sound, they may think, oh, I'm just going to dip into this money to help pay my mortgage. I'm going to repay it. I have every intention to repay it. And they don't. And then that money is gone. It's been misspent or mismanaged. Now there's no money for little Johnny. And yeah, you could, have someone sue the sister that you appointed as trustee for that person. But if she doesn't have any money, you don't want to sue your sister. You don't want to put her in that position. But if she doesn't have any money, little Johnny's now stuck with no funds. So you need to think about, who the right people are. And sometimes it really is a bank or a trust company that should be managing funds, because that takes care of the problem that when parents or, aunt and uncle who are the peers, who are a generation above little Johnny, when they can't serve, if you have a bank or a trust company in there, they're going to be around. Yeah, the staff might change 50 years from now, but that organization or some successor is going to be there. And they have insurance. They have, they're regulated either by, a bank regulator or by the attorney general in the case of a nonprofit like Achieva. So, and they know what they're doing. They know the benefits. They know how to deal with these things. So those are important things, to think about when you're thinking about who should these fiduciaries be. So I'm going to, and I wanted to mention those execution requirements for financial powers of attorney. It does need to be executed in the presence of 2 independent witnesses. So people who are not named in the document. So, mom and dad can't witness little Johnny signing the power of attorney that appoints them as agent because they are named in the document. You need independent witnesses and a notary who is not also a witness. So we oftentimes see powers of attorney fail because the execution requirements didn't meet our statute. Likewise, I mentioned there are certain powers that have to be expressly included in a financial power of attorney. And if they're not, the agent can't conduct that transaction. And that includes things like making gifts, changing beneficiary designations, creating trusts, such as supplemental or special needs trusts. So all really important things. So, we need to think about who would the initial agent or guardian be, who would backups be, making sure they have the right, qualifications. And we talked about the filing for guardianship. 2 things that I'll mention is, when you do file for guardianship, it's the court that determines whether someone lacks capacity, and they do that based on medical evidence. So a doctor will give typically an affidavit, a written affidavit, saying this is the person's condition, prognosis, and the doctor believes that that person isn't able to meaningfully communicate decisions, so he or she needs a guardian. Normally, the person who's the alleged incapacitated person doesn't have to come to that hearing. The doctor can say, no, it would be harmful for them to come. Can't say they won't understand it. It has to be harmful, right? Because it would cause anxiety. It would cause them disruption, or they are immunocompromised and they shouldn't have to be out in public. If the doctor excuses them, the judge won't require them to be there. But the person who's being adjudicated to be incapacitated, or that proposed incapacitated person, does have to have certain statutory notices. They have to be read rights, even if they won't understand them, because the court is potentially taking away their rights. And the other important thing, a change to PA law that sort of was simultaneous with this more sophisticated guardianship tracking system, was a requirement that the proposed guardian, even if it's parents or someone who we really trust, they need to have background checks in Pennsylvania now. So if you're a proposed guardian for your child, even though it seems nonsensical because you would never, ever do anything that's against their interests, you have to have a background check from, Pennsylvania, and if you lived out of state within a period, that other state. And these increased guardianship protections really came into place because there were some bad actors. Some guardianship agencies out in the East Coast took advantage of people's money, and those bad actors then resulted in statutory changes that make it harder to get a guardianship, that protect the incapacitated person's rights and ensure that the proposed guardian has been properly vetted. So we're just about out of time. I just want to see if there's anything else that we didn't cover quickly. And I don't think so. So there's a lot of detail in the slides. I'm happy to answer questions, either now or separately. And I hope that you all learned something. So take care and enjoy the rest of the day.
Nora, one question that came up online, if you would, might be helpful. The person asks, if you want to get a credit card for your disabled child to establish credit, can you use a POA to limit the amount they can charge?
So I guess there's a couple ways to do that. And if you are truly taking out a credit card in the name of that disabled child, you would need to either have them open it and then you limit it as the agent, or you as their agent would apply for that credit card and then could set the parameters. I don't deal a lot with credit card companies in the power of attorney context, but I can tell you that by statute, a third party, whether it's a bank, financial institution, they have to honor the authority of and the direction of the agent unless they think something's defective with that power of attorney. So if mom says, I want to open a credit card in little Johnny's name, if he has no credit, they're not going to give him a high limit anyway. But in theory, yes, that should be able to happen. And if the credit card company, doesn't follow it, then a nasty letter could be sent to them. But they may have their own sort of protections in place just for, credit fraud and reporting purposes, which I'm not familiar with. Question? One more question. Yeah.
Yeah. I work with medically fragile special needs children and helping the families to get talking about power of attorney versus legal guardianship. I oftentimes tell them, go online and just download the power of attorney paperwork. You're saying not to do that. Do you have a way, or is there something I can tell our families to go to? Because it is just paperwork, they don't necessarily need an attorney for that. Do you have something that I could provide to my families to get them that power of attorney paperwork?
Yeah, that's a good question. I'm not saying don't do that, right? I mean, that certainly something is better than nothing. But one of the problems we see is people will download that paperwork, have it signed, fast forward a period of time, and we need to rely upon that power of attorney, and it is defective, right? It didn't follow those statutory execution requirements. It wasn't notarized, or we didn't have independent witnesses, or it didn't allow for trust creation, and now mom and dad can't fund this trust. And if little Johnny can't sign a new power of attorney at that point, then we're forced to go to guardianship. So, I mean, that's still a good resource. There may be forms that Achieva or other organizations put out there, but I can tell you that, and maybe the Achieva folks can speak to this, but there are on occasion sort of these pro bono workshops, right? And I know Achieva does it, the bar associations do it, the law schools do it. where there will be times where people can come in and actually have talk to the family and think through some of these things. What powers do we need to give? If mom and dad can't serve, who should it be? Mom says my sister, and then we learn she's filed bankruptcy 10 times. We say, nope, she's not a good agent. Let's find somebody else. So there are these clinics where you can actually sit down with an attorney, get that form printed, and make sure it's signed properly. So I would suggest that, you be on the lookout for those, or ask somebody to let you know if that's coming up. And then there probably are better resources for forms online. And I know that there's things like neighborhood legal services as well, which may provide some sample forms. And, I know that there are definitely pretty good healthcare power of attorney forms online. The financial, I'm not certain about. Maria, do you or Patty or anybody else have anything to add there?
No, I don't. And I would look to Lee in terms of we are not offering those forms at this point, right?
No, but I would say that we do have that. If you wanted to talk to somebody, we have the future legal clinic.
Yeah. So what Lee's? Oh, she's going to get the microphone.
We have a legal clinic coming up that there's 30-minute slots that you get. We have pro bono attorneys that are working with us. Nora, I think, is one.
Right?
Yeah, I think it's October 29th. It is October 29th. So that might be a good time if you had some of those questions or you want legal documents that you currently have to look at, that might be a good opportunity to try something like that. And then Nora, have you ever used the Allegheny County Bar Association medical healthcare directive that they have online? Like, what's your thoughts on that?
Yeah, I know. I have a partner of mine who uses that all the time as his default healthcare power of attorney and advance directive. I use a different form personally, but that form that's available on the Allegheny County Bar Association website was developed and vetted by a really sophisticated group of estate planning attorneys. So that form is good, and it will have execution instructions. I think it's the financial powers of attorney sometimes where there's, the statutory requirements are a lot more rigid, and that's where we see some problems. Yes.
2 questions. What would you say to a mom who is a reluctant parent to move on guardianship?
So the question is, what would you say to a parent who's reluctant to move on guardianship, right? Let's say has a child who's now over 18, presumed to have capacity. We really know that person probably can't sign a power of attorney, but, for whether it's financial, I don't know, you just don't want to do it, move to the guardianship. What would my recommendation be? And I would say, well, like I mentioned earlier, it may be that third parties continue to deal with you and you take a wait and see approach. You wait till someone denies you access. And at that point, you get the guardianship. The problem can be that is sort of like a very reactionary crisis time, right? And the guardianship process, it normally takes at least 45 days. So if you are in this crisis or this pickle and you're being denied information, you're going to be very frustrated by that. Now, there is an emergency guardianship filing, but it's more cost. In some ways, it's more time, and it does require a showing of irreparable harm. And at least in Allegheny County, our judges aren't going to make that finding unless they think it's really apparent. So it's not just going to be mom's frustrated. It's going to be little Johnny is being denied access to some vital care. So we need to have a guardian in there. So I would kick it back, but I would say, one of the things that's important is if you take that wait and see approach, it may be a situation where you're just frustrated and then you have to wait for 45 days. But I would also say, what if, forbid, something happens to you? And maybe you are the only advocate and all of a sudden you are not there. Not only do you sort of have to have that roadmap in place, like your sister knows to come get little Johnny or your neighbor or whatever the case may be, but at that point, those third parties that are still relying on your authority because they know you, they've known you since he was a minor or she was a minor, they're not going to rely upon that other person's authority. And what if whoever steps in this crisis when you're not there is someone who's not going to do right by little Johnny or take advantage of him? So you may have more peace of mind going into court to get a guardianship. That way you're not going to have this crisis where you're denied access. In that process, you may have someone that you would want to be the backup for you appointed as your co-guardian. Even if you don't, if you're the only guardian and then all of a sudden you're not able to make decisions, that's going to then prompt somebody to go back to court and have a successor appointed. So you may obtain some peace of mind knowing that the court is watching if you don't have a really good sort of support network to assist you. So that would be what I would say, and I would, kick it back to the client to make the decision.
And my other question is, if you have mom who has guardianship and something happens to her before brother is of legal age, if there's a void, what happens?
Yeah, so mom is the only guardian. Let's say the plan is for the younger brother to assume guardianship or to be involved when he's over 18, but he's still 16 and mom passes away. At that point, there's a vacancy in the guardianship. So someone would need to go into court to ask that somebody else be appointed as guardian until such time as the younger brother is of age. So, someone would go in and ask for an aunt or an uncle or, a social service agency. But that's where, even when we're doing sort of naming guardians under wills and things, a lot of clients or families have very strong opinions as to who should care for their kids, right? They may know that all of the aunts and uncles love them, but like this side of the family are, you don't trust them. They have problems. It needs to be this side of the family. And that's where if you don't proactively have someone on this side of the family installed or waiting in the wings, it may be someone that you wouldn't want to be involved swoops in. So, because the court's not going to know that history. So that's what I would say. Yes, one more question.
Range of the cost of getting guardian.
Yeah, so the question is the cost of getting guardianship. And I would say, and you, again, you have attorneys bill differently and I'll have all sorts of hourly rates. I would say, generally speaking, it's probably going to be about $2,500, give or take. But they do bill hourly, and some attorneys will bill $100 for a will, some bill $5,000. So it just depends where you go. But and these happen less frequently. But there are clinics, and I know that the Western Pennsylvania Trial Lawyers Association was trying to do them for a while. I wasn't able to participate, so I'm not sure if that got off the ground or what became of it. But there are ways that you can get pro bono assistance with guardianship too, whether it's through neighborhood legal services or maybe attending one of the Achieva clinics, and then an attorney says, look, I'll work with you, because the guardianship process, unlike a power of attorney, cannot be accomplished in half an hour. It's a 2-month affair at the least. So there are other options out there. So the court filing cost is, I should know what it is, but let's say it's $150. That would not include that, but there is a way, if someone is indigent, you can ask the court to waive the court fees. So normally the fees that would be involved would be the court filing fee of maybe $150, whatever it would be. There would be an attorney fee unless it's pro bono. And then sometimes the doctors will charge to give their medical report. I used to see them charge more often than not. Lately, and particularly if it's a younger person, I don't see them charge. So, but sometimes they do charge, $800 just to complete an affidavit. All right. Well, thank you, everybody. Have a great afternoon.